The views, thoughts, and opinions expressed on this show belong solely to Let's Talk TCI Real Estate and not that of Keller Williams TCI or any of its affiliates. Any action you take upon the information provided on this show is strictly at your own risk, and Let's Talk TCI Real Estate guests or hosts will not be liable for any losses and damages in connection with the use of the material. I am not an investment advisor, broker, or dealer. Good afternoon, Turks and Caicos. Good afternoon, everyone out there in the wider world who are listening today. Welcome to another edition of Let's Talk TCI Real Estate. As just giving you a minute, I ask you to please like, share, follow the page, and also drop a line in the comments section and let us know where you are listening in from. I know we have followers who are always from the Bahamas. We've had persons from the US. We've had persons from the United States, from the United Kingdom. Please let us know where you are listening in from. Also, I ask you, if you have any questions or any comments, please feel free to do so while we are having the conversation so that we can see it in advance and be able to get those questions answered for you. Okay? Again, like I say, please like, share the page. And also I'd like to say, please bear with us. The internet is a bit slow today. So if for any reason you see us slow down, it's just the internet, but please stay tuned and connected to the internet because I think it is an exciting show. With that said, I'd like to get right into it, and I am so excited to have with me a professional, someone who's well seasoned as an attorney, someone who has proven herself time and time again as an attorney, and I am going to leave it up to her to introduce herself to you, our listening guest today. Take it over, Ms. Sarah.
Hello, my name is Sarah Knight. I'm an attorney of about 22 years standing. I am the current vice president of the Turks and Caicos Bar Association and a partner at the firm of Mizik and Stanbrook. And about probably 90 to 95% of my work practice area involves real estate. So hope I can answer all the questions. Okay.
Thank you so much, Sarah, for that introduction. Yes. Trust me, I am excited to have you here today. And I always say to people, I said, tune into the show. I said, because there's information that is being presented to you. Trust me, it's free advice. I said, you don't have to look nowhere for it. I said, count it a privilege. This is great information that you can have to help improve yourself in whatever aspects of real estate you are looking to do. So I am excited about this information today. As usual, what I like to do is to dive right in because of the short period of time that we have. And I'm going to start with our first question for you today. Of course, you know, I'm a real estate agent, and a lot of times when someone is making an offer on a property, you know, they are not sure as into how they must take title to that real estate that they are purchasing. So for today, I would like for you to explain to us what are the different ways in which you can take title to a property in the Turks and Caicos Islands.
Okay. One of the ways is obviously in your own personal name, or it can be in the name of several persons if you're buying the property jointly. Oftentimes it's with two spouses who will both wish to be on the title, or sometimes you have family members or a group of persons who are buying the property together. So title can be taken in your personal name or your personal names. If there is more than one person to go on the title, then you can either take it as joint tenants, which is most common for spouses because there's an almost automatic right of survivorship without having to go through the whole probate process if one of the persons dies. If it's a partnership or a group of couples, then tenants in common. is how they would usually take title, but it's in personal names. Another option is to take title in the name of a company, and that may be done for various reasons. Quite often, persons would like to do that to limit liability, for example, so they can go that way, or it can be done. It can be taken in a trust, and it's put in the name of the trustee of the trust. So those are the main ways that title can be taken. They don't necessarily have to decide when they execute the preliminary agreement, but there are, they can put one on the preliminary agreement, and then once they've thought about it or discussed it with an attorney or someone else, they can change that when it's time to go to contract. So
okay, and saying
personal
that,
names,
go ahead.
company, trust. No, I was just repeating it. Personal names, a company, or a trust.
Okay. Just two things I want to go back. Well, the one where you have tenancy in common. Please remind me what is the best for that meaning? Because I know you said joint agreements is best, like husband and wife, right? So if it's for tenancy in common, you would more like if someone who is not a family member.
It can be. What a tenants in common is that one person or a couple, for example, will own a specific share in the property. So if it's maybe two couples are buying a property together, then you could have you can have husband and wife on the one hand owning 50% share in the property, and the other husband and wife, for example, owning the other 50% share. So it divides the ownership by way of shareholding. So you have a precise interest in the property, and that can be transferred, or it goes to your estate once you die to be dealt with. So it separates it.
Okay, and because you said it goes to the estate, so if one couple pass away, and before it goes to their estate, but do they need consent from the living couple as to if anything doesn't happen to the property, like they decide they want to sell it and the estate is not administrated upon or probated, how does that work?
They can sell their 50% share in the property, for example, if they wanted to. As between themselves, they would normally be joint tenants, so it would be unusual, but obviously not heard of for both of the couple to die at the same time. But if they were, then their 50% would have to be administered as part of their estate. So they would need to go through the estate process, and then whoever's the beneficiary under their estate would have their 50% share. Okay.
So is there an advantage of choosing one method over the other when you're thinking about taking title?
It depends. It depends very much on what you intend to do. For example, if you're buying a property that's an investment property and you're looking to do sort of short-term rentals or long-term rentals, then you may want to take it in the name of a company, because that gives a layer from you personally in terms of liability. So that's one thing that sometimes people decide to do. Obviously, it has sort of the same effect if you just ensure that you are adequately covered in terms of insurance. There isn't really one benefit over the other. It just really depends on your personal choice. I think it's important to know the options and to decide what's best for you in each case.
Okay. And also, you spoke earlier about if you execute a preliminary agreement, you can put it in one name, and then when you are at the stage of the purchase and sales agreement with the attorney, that they can help you in deciding also if you want to change the way you lodge that title. So if someone decides to do it as a company, how long would that company take to be formed in order to have that title, the company, or as a name on the sales and purchase agreement?
It takes between one sort of business week and 2 business weeks. It can be about 1 week as average, but it can take longer just, just because of certain delays. But between 1 and 2 weeks is the normal time. Most closings are longer than that. So there's adequate time usually
to have it formed. Okay, that's good to know. So must the company, I know we're talking, must you take title in a company name that's registered in the Turks and Caicos Islands?
Yes, it must be a Turks and Caicos Islands company, but the shares in that company could be owned by a separate foreign company, for example. So it's not necessary that the shares in the Turks and Caicos Islands be held by a Turks and Caicos company. Okay. But it has to be a Turks and Caicos Islands registered company on the register for the property.
Okay. So then what happens in the event that that company is not kept up to date, and then in future that particular person wants to sell their real estate? How long does it take to reinstate that property, or what's the process then?
Well, you have to pay out all the fees and the penalties that are due for allowing the company to lapse. If the company is struck and it's been struck for sort of less than 10 years, then that's a much simpler process. You can simply pay everything and deal with the registrar of companies to have the company reinstated. If it's longer than 10 years but less than 20 years, then you need to obviously pay up everything that's owed, but you need a court order to have the company reinstated again. It's important to note that if you own property in the name of a company and the company is struck, although it's unusual, it's not impossible for the Crown to actually lay claim to the property bona vacanta, because the company no longer exists legally. So that's one thing to be mindful of if you do take title in the name of a company.
Right. So how long do you reckon it takes before the Crown does something like that?
Well, it really depends. It's not something that happens often, but it's possible. And
of course, something like that is very difficult to get it back.
Oh, yes. The company no longer exists. So, yeah, it belongs to the Crown if they move that way.
And also, when you spoke about the Supreme Court, about getting it reinstated through the Supreme Court, that's also a lengthy process, I'm thinking.
Not necessarily, because if oftentimes if all the back fees are paid, then there's no objection to the company being reinstated. So that can be done sort of by a consent order and a simple hearing. So that's not necessarily a lengthy process.
Okay. And by just talking about this in reinstatement, this is why it's so good to have an attorney involved in a transaction, especially of this nature, because they will be able to direct you as to how to move forward with something like this.
Yes, yeah, and to tell you of any pitfalls that you should be aware of.
Correct. All right. Just again, if you have any questions, please send it through. If you have any comments, please make those comments. We want to make sure have those answered for you. Okay. I would like to ask you something on another note. We have a lot of properties that were given to residents on island through the Crown. Okay. Mm-hmm. Can you help us to understand? First of all, I will say this is in no way trying to tell you to sell your property that you have received by the government. But it is a great question, because you do have, sometimes people have reason why they need to sell, even if they have obtained their property through the Crown. So that's what this is about, just making sure people understand what their rights are, and what they can do. So if you do have someone who have obtained their property from the Crown, I want you to be able to explain this process to us. Questions like, does everyone have the same lease agreement? I guess we can go in stages. Would everyone have the same lease agreement from the Crown?
Not necessarily. Everyone who obtained a lease at the particular time or in a certain year, their lease agreement should be the same. But obviously the first step is to obtain a copy of the registered lease and to make sure that the terms are as you would expect them to be and as they are. So everyone with a lease of a certain year, their lease should be the same. There are certain sort of trigger years where things changed a little bit, and the leases will be different from previous leases granted. But for a particular time, the lease should be the same.
Okay. I mean, that's good to know, because sometimes in real estate, we're just so accustomed to, telling people how it operates in one way, not knowing that there is times when the lease may be different, like you say, depending on the year of when the lease was obtained. Okay.
That's true. And I should just clarify and say, in answering that, I'm talking about residential leases primarily.
Okay. Yes. Thank you. Yeah, because it is a difference. Yes. Okay. So how long do you need to have freehold of a property that was obtained from the Crown before you are able to sell it, to sell it?
Well, if you bought the property from the Crown, then there will be a Crown charge on it for the first 10 years. You can sell it within that 10-year period, but you can only do so with the consent of the Crown. And there are certain obligations that must be fulfilled by the purchaser who buys within that time period. And even within the first 10 years of you having freehold title, within the first 3 years of the title, if you sell in that period for a profit, then the Crown is entitled to the profit that would be made on the sale. So
Okay, so let me
gain in selling it within the first 3 years.
Okay, so if you sell in the first 3 years for a profit, the Crown is entitled to the profit. But if you sell it, just say you sell it within 9 years before that 10 years is up, are they still entitled to the profit?
They're not entitled to the profit. They have to consent to the sale. And if you are selling it to a non-islander, then obviously the discount that you had gotten in buying it from the Crown has to be repaid to the Crown together with the interest under the Crown's charge.
Okay, and they will calculate those interests.
Correct.
Okay, and what happens if you're selling it after the 10 years?
Yes, they will. And they will require the person purchasing the land to, if it is an islander, to prove that they're an islander, and also to assume all the obligations that the first owner had when they were given the property.
Okay, we blanked out just a minute, so forgive me if you answered what I asked, but so what happens if they're selling their property after the 10 years? What is the requirement?
After the 10 years, the Crown's charge, now they're removing the charges automatically, but in some instances they may miss it. So you should apply to have the Crown charge removed. And even in some cases, if you have the charge removed, there may still be a Crown restrictive agreement registered on the title to the property. So you would need to look at that and see if what the conditions of that are. In one case, they provide that there must be certain specific type of development on the property, and that it can only be used for certain things.
All right, that's good information. All right, so, and at that point in time, they have the freedom after the 10 years to sell to a belonger or a non-belonger.
Yes.
Okay, but anything before that, it must be preferably a belonger, but if not, then you have to deal with any penalties, any discounted fees and charges.
Yes, and in both cases, you obviously need the Crown's consent to a transfer.
Okay. How long does it, I know you don't know how long, but how an estimate time of what you usually look for before you get that consent? And is there any reason why the Crown can deny consent of doing that transfer?
It depends very much, the length of time. It's gotten shorter as I guess everyone has gotten used to the process, and government has gotten more responsive. There are various reasons why they can deny it. I guess the main one is if it's apparent that it was the conditions on which the property were given were not met, and there was never any intention to meet those conditions, then they have
the right to deny.
Yes.
Okay. I didn't really realize that the Crown had to give consent. I knew about all the penalties and everything else, but I didn't realize that on top of that, they still had to give the consent to have the transfer done.
Yeah.
Okay. Do you know of any instances where they have denied? I'm just generally asking.
I'm not aware of any, no.
Okay. All right. All right. So I want to just go into something else. So recently, the government has put forward a Stamp Duty Waiver initiative. And I just want you to be able to explain what this waiver initiative is about.
Okay, they introduced a sort of a 3-month stamp duty discount that can be applied for. It started, well, first of all, I should say it does not apply to extended payment agreements. It only applies to transactions between $25,000 and $2 million.
Sorry, just one quick question. Sorry, because you said extended payment agreements. Does extended payment agreement still exist on stamp duty currently?
Oh, yes, you still have to pay the stamp duty.
No, not to pay the stamp duty. I mean, do they allow for extended payment?
They allow for extended payment agreement, not on the stamp duty.
Okay.
Not on that. That was I guess a promotion that was done.
Because I remember they had it before. Yes. Okay, go ahead. Sorry.
So the property has to be valued at less than $2 million and obviously more than $25,000 because there is no stamp duty payable on anything under $25,000. And it cannot be combined with any other stamp duty discount. For example, the first-time homeowners discount. You have to choose which what you want to get the benefit from.
Right.
And it's given at the discretion of the Minister of Finance. So if you meet those, then there was a 75% discount that was in effect from the 21st of September to the 20th of October. So that's obviously passed now. And we are currently in a 50% discount, which will run to the 20th of November. And then from the 21st of November to the 20th of December, there is a 25% discount that can be applied for.
Okay.
And to apply for that, there is a form of affidavit that is available that must be signed by the applicants. That provides that there will be a restriction placed on the title of the property, that it cannot be sold within the first 5 years unless the discounted sum is repaid to the government. You have to provide a valuation for the property to confirm that it's valued at under $2 million. You have to provide a copy of the agreement for sale. And those all go initially to the collector of stamp duty, who reviews them, and she will provide a letter to say if the discount is being given. Once you receive that letter, then you have 5 days to submit the transfers, the letter, and the discounted stamp duty sum to the registry, to the land registry, to be registered.
Okay, so what original documents need to be, what those documents needs to be in its original form to be presented to that department? They will need the original affidavit, original valuation, and the agreement for sale. A copy of that can be provided, but they do require that hard copies be delivered to the collector of stamp duty before any letter is issued. Okay. And I'm just asking, you may not know, because you said that an appraisal is required. What happens in a case where, for example, you have a cash buyer who decided on a purchase price, for example, of $75,000, and now they go ahead and have the appraisal done only for the purpose of this waiver, and the appraisal comes below what they are purchasing or agree to purchase for. So, for example, $60,000. Would that person still be able to get such a waiver, even if it's only on the appraised value?
They can still get a waiver, but what the waiver is on the sum that they agreed to pay. So if they agreed to purchase the property for $75,000, then that's the consideration. So that's what they pay the stamp duty on, and that's what the waiver would be.
Even though the appraisal came in less?
Yes.
Okay. Okay. I mean, that's good to know, because these are just questions persons have asked, and they're concerned about, hey, what about, there are buyers. I do know of 1 or 2 buyers who have purchased cash, but their concern was, hey, we purchased cash, but we know that the appraisal is going to come in last because of, for whatever reason. So they were doubting whether they should take that chance to even apply for the waiver, seeing that the appraisal did not match the purchase price. So, I mean, it's good to know that it still will be considered, even in such a scenario like that.
Yeah, I mean, you submitting the purchase and sale agreement, so that is what you contracted to buy the property for. I think it's what you were prepared to pay for it. So.
Yeah. Okay, I think even they were thinking a line of, if you buy through the bank lands based on what the appraisal come in at as a percentage, and they probably were thinking along the same lines. And so that's why the question.
Yeah.
Do you feel, or have there been any hiccup in the process since you have been administering any of these waiver applications?
There haven't been any hiccups. I know that it's important to make sure that you abide by the time limit that you're given to submit the documents, because even if you get the letter for the stamp duty waiver, but you take longer than the 5 days. Initially it was 3 days, but then it was the letter will now say 5 days. If you take longer than the 5 days to apply for to submit the documents to the land registry, then I can see that being a problem, and you would lose the entitlement to the waiver, I believe. I haven't been I haven't had that issue personally, but I could see that it would be a problem. So I have to say the department that I've been dealing with on it have been very responsive to date. So initially going into it, I was fearful that, the times weren't going to be sufficient to allow, but I haven't had that experience so far.
So then at what stage do you tell a purchaser to apply for the waiver? What stage of the process?
Well, mine, I've closed on them all before, because you only have the 5 days once you get the letter to be able to submit the document. So you really need to have sort of everything, everything closed and in hand.
Okay.
Is obviously the preference.
Okay. Yeah. All right. That's good advice. Have it closed so that once it's approved, you don't have to worry about the deadline. You just can submit it all at hand.
Yeah.
Okay. Just because we were talking about this, and you had mentioned earlier that you would not qualify if you take up the opportunities just of the first-time home owners policy. I'm just bringing this at the top. Do you feel, or describe for me the process of obtaining that first-time home owners discount? I'm just trying to, for a buyer, seeing what makes more practical sense for them. Can you give an idea about the process for the first-time home buyers benefit?
It depends. I probably can't give a description of the process, right. But I think it depends which one you go for will depend on how much you are saving in stamp duty, because the first-time homeowners is that's capped at 20,000.
Right.
So if you would only be paying a relatively small sum in stamp duty, in any case, perhaps it's a raw land purchase on one of the outer islands where the rates are lower, then you may be better off to to forego this and instead reap the benefits of the $20,000 further down the road. So it's a calculation, depends on what you would be saving.
I like what you say, capitalize on the $20,000 further down the road. Also, do you know, I know that the first-time home buyer policy has been going on for a while now. Do you know if there is a cutoff time period for that policy?
As far as I'm aware, there's no sort of end to that policy. I guess it's a matter of when of a change in the legislation again to say, okay, we're no longer accepting this.
Okay.
One thing I should mention on the stamp duty waiver as well is that the fact that it's been given will be gazetted, just to show the amount that's been discounted and who the purchaser was. That's a requirement of the section that the discount is given under.
Okay. And in a case like that, will that charge be automatically removed, or again, will they need to make sure, just say, not the charge, the charge or restriction after 5 years?
I think it would probably be a matter of, the interested party writing in to say the time is now expired, please remove the restriction. So.
Okay. Yeah. All right. Another question I have here is, as an attorney, are there any particular concerns that you find that buyers or sellers have that you feel is relevant to share that can help someone, who have gone through the same thing or who is looking to buy or sell?
I think in either case, it's important to involve an attorney at an early stage. If you're buying, then what your attorney can do for you once you've signed the sale and purchase contract is going to be very limited, because you've already committed to the terms of that agreement for sale. And it may not be that you're aware of all that you should have been aware of. And also, sort of discuss what you want to do with the property so that they're able to advise you, as the best course. So I think involve an attorney early, sort of earlier in the process, rather than waiting to, to come to closing and then say, let me get an attorney to close the transaction for me, because you're already committed to whatever was agreed to before your attorney was instructed. So I think that's important, whether you're buying or selling. And I think it's important to note that if you're getting financing for a property, that can sometimes take longer than anticipated. So start that process as early as possible. Provide what the banks require of you to be provided, and be patient.
Right. Okay. And I'll also ask you, can you explain because we're talking about, like you say, engaging an attorney early, what is actually the responsibility, the role of the attorney from a purchaser's standpoint at the closing, and what's the role of the attorney from the person who is selling? I'm just trying to point out the need for an attorney during the closing of a transaction.
Okay, if you have an attorney who's acting for you and you're purchasing the property, then that attorney will have, before the closing, they will have checked the title of the property is actually in the name of the person who you contracted to buy it from. They will have checked that the property is where you think it is, and it's the approximate size that you think you're purchasing. They should also have checked the access to the property. At closing, they will usually receive a survey which will confirm whether or not there's any trespass or encroachment from any adjoining property onto the parcel that you're buying. And they will obviously be the person that you will provide the funds to be released to the seller or the seller's attorney once you close. And most importantly, also for the purchaser, they will lodge and submit the documentation to the land registry to be registered. It's important to note that although you've closed, you must have the title registered in your name to complete the transaction. I'm aware of a case where persons bought and sold property, and unbeknown to either of them, they didn't have any attorney involved. They paid the money, they got a form of transfer to say that their property was theirs, but neither of them realized that it had to be registered. So, that's important to know.
Important, yes.
Yeah, that's important to know. And the attorney acting for the purchaser will, make sure that that's done. The attorney acting for the seller will be responsible usually for preparing the agreement for sale, preparing the closing documents to transfer title and everything else. And they will, if necessary, they will liaise with the bank to obtain a discharge of any mortgage that may have been on the property. And obviously at closing, they will take receipt of the purchase price, and they will usually hold that in escrow to allow the purchaser to have sufficient time to submit the documents for registration and have them accepted at the land registry before the funds are dispersed to the seller.
Well, trust me, even though I know the process, just hearing you separate the two, it's a lot of responsibility on the attorney during the closing of a transaction. And I really want to stress that because a lot of times in real estate, we recommend that they have an attorney, do the final closing. And sometimes they take the advice, sometimes they do not. And at the end of it, they realize that it's not as simple.
An attorney.
Yes, like it is not right. And it's like, okay, please let me call Sarah and tell Sarah deal with this for me. No, because because then at the end of the day, they don't realize that it is a lot of, when I say a lot of work, you need to be focused on what you are doing, and you need to hand it over to a professional who knows what to look for and who knows exactly how to deal with it. Because you were talking about the discharge of charge and everything like that. You don't want someone dealing with all of that on their own, because it's only going to be more stress for them than ease of mind. And so I think it is very important to have an attorney to deal with that. Yes. So thank you for breaking that down. So we can know that as a purchaser as well as a seller, it is important to have an attorney. And I do know of an instance as well where a property has been sold and the attorney was not involved. Of course, all paperwork was signed and registration was never complete. And they did not have the understanding to know, hey, until that's lodged in Grand Turk, you still do not own that property. Yeah. And they become at a disadvantage, because if, just for example, not wanting to happen, if the seller passes away, now, it becomes more difficult for them to obtain that title. And sometimes you end up with misplaced documentation if you don't lodge it right away. So that creates even a further disadvantage to that purchaser.
Yeah. Yes, and in both the cases you mentioned, you've been dealing with reputable persons. You could have a dishonest seller, and they could sell the same property a number of times, and if it's not registered, then that's a big problem. But the instances that I know where that's happened, it was just through lack of knowledge. Neither realized that it had to be registered. And also in that instance, if it's not registered within a certain time, you incur stamp duty penalties. So that's a whole nother, problem to be worried about, as it were.
Definitely. Well, it is 45 minutes, believe it or not. We have touched on the different ways to take title. We've also touched on the Stamp Duty Waiver. We've also touched on Crown land policies in relation to selling property. And also we talked about, the role of the attorney at the closing. I think that's a lot of information that we have shared today, but I didn't see any questions or comments. And I'm sure people are glued and listening in, because when I checked my Facebook today, I had about 600 and something likes on your poster, Sarah. So I know people are listening to the conversation today, because it is a real important topic. With that said, and then before we close, if you have any closing remarks, I will allow you to do so at this time. And also I would like you to share your information for anyone who is interested in contacting you about real estate. Like I said before we started, and I'm not just trying to blow your horn, I've done several transactions with Sarah, and she is a real professional. And I encourage you, if you're looking for someone who is going to do justice, and I had a purchaser on before, and she said during her transaction, she realized that you need someone who understands real estate when doing a real estate sale transaction, not just any attorney. And I understand where she's coming from. And I believe Sarah is a real estate attorney, and she can assist you with your closing and your transaction. Please, any last words, and please share your information.
Okay, thank you for that. Any last words? I think, it's important to get on the property ladder. The earlier you do it, then, in a sense, the easier it is. Even if you get something that is not your ideal property, at least, you have something. It's an asset, and it's yours. So, it's a good investment. Whether you end up building a home on it or you sell it and you buy something else, then at least you can see where your monies are going, as it were. And happy to help. Whenever I can. I'm at Music and Stanbrook, and you can sort of find me there all the time. So
yes. So you share Music and Stanbrook. Do you want to share at least Music and Stanbrook's info, or do you want to share your email?
Sarah at musicstanbrook.tc is my email. I guess the phone number is 946-4732. So.
Okay. Well, thank you so much, Sarah, for coming on. It was a pleasure to sit and have this conversation with you, and it was a pleasure for your kind advice that you have shared with the listening audience today. Thank you so much. All right. And for those listening out there, I just want to say, please stay tuned next week. We will actually be speaking about, there is a affordable home scheme that is actually in the Blue Hills area. We want to have those persons on to talk about this opportunity, as we know that that's a price point that a lot of people are looking for. And so please tune in next week as we bring that information to you. So until then, stay safe and remain blessed. Have a good afternoon, everyone.